Continuing on this episode of Law Weekly, reactions trail the Supreme Court judgment on the presidential elections. We have the views of a senior advocate of Nigeria, Adamson Adeboro. Also showing on the program, highlights from the second annual conference of the National Association of Family Court Judges, Magistrates, and other family court practitioners, plus our recap of the top legal stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. The Supreme Court of Nigeria on Thursday, October 26, finally laid to rest the legal dispute over the outcome of the February 25th presidential elections. The court dismissed the appeals filed by the presidential candidates of the PDP, Atiku Abubakar, and the Labour Party's Peter Obi. The court also dismissed the move by Atiku Abubakar to tender fresh evidence of certificate forgery against President Tinubu. He then went on to pronounce on the merits of the petition on issues ranging from the allegation of widespread rigging, the failure of the president to score 25% of the votes cast in the FCT, and the effect of the failure of INEC to transmit results electronically to the IRF portal.
What exactly is the IRF portal? The court below held that the IRF portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IRF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IRF portal fails, it does not stop the collation of results, which up to the last election was manually done. Truth must be told, the non-functioning of the IRF may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IRF is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IRF portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1. The Nigeria Police Force, and 2. Agents of political parties. End of quote. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IRF portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IRF portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation.
One of the lawyers to the Labour Party, Kenneth Okonkwo, strongly disagreed with the judgment. Amongst other things, he noted that the court was silent on the issue of the money forfeited by the president in the U.S.
As a fine imposed on the second respondent for the proceeds of narcotics and money laundering by the District Court of Illinois. I sat down too. I did not hear it. And I wonder whether that was swept under the carpet or was an oversight, because the lead judgment was detailed on all other issues. And they said all the issues there have been overtaken by event in all our own issues. And I did not hear the issue of the forfeiture. And so that's why I said I disagree respectfully, even though the decision is binding.
A senior advocate of Nigeria, Adamson Adeboro, also shares with Law Weekly his reaction to the judgment of the court.
The Supreme Court has spoken. It's the final court in the land. No appeal can be filed against the judgment of the Supreme Court, except to God Almighty. Be that as it may, the issue of the forfeiture was exhaustively discussed by the Presidential Election Petition Tribunal. And mind you, the judgment of the Supreme Court today was a mere epitome. It just summarized. So by the time you read the full judgment, you will find the decision of the Supreme Court as regards the issue raised by that counsel. I trust the Supreme Court will have. They will have done justice with it. You know, when you hear people saying all manners of things, it is sentiment carries too far. We are talking about justice here, but justice we are talking about here must be according to what the law prescribes. If the Constitution, which is the ground norm of Nigeria, is saying you cannot hold me responsible for a crime I was committed over 10 years, there's something anybody can do. Sometimes you wonder why people sit down in their armchairs and be criticizing Supreme Court justice or the court justices. These people decide matters according to what your law prescribes. They are not lawmakers. They are mere law interpreters. The National Assembly makes the law, but the justices interpret the law and give meaning to the words as used by the legislators. While the Electoral Act 2022 was passed last year, I am sure you are one of those who were jubilating. Say, oh, we have got to our Eldorado. Yes. But mind you, Rome, according to the Victoria Ditch, was not built in a day. Our electoral jurisprudence is evolving. We are developing. Now, what the Electoral Act 2022 introduced to our electoral jurisprudence was beavers to capture, to authenticate those who were to vote. Now, IREF was not mentioned in any of the provisions of the Electoral Act 2022. None. If there was a mentioning of IREF, perhaps in INEC manual or guideline. Now, guideline cannot supersede the provisions of the Act itself. And again, the Act itself, if it's a contravention of the provision of the Constitution says it shall be null and void to the extent of its inconsistencies. Now, if you look at all this, remember that the Electoral Act 2022 gives INEC the discretionary power to adopt any system in transmitting the votes from the polling unit to wherever. Now, if the issue out there is that, oh, INEC promised the entire world that we're going to use IREF. A promise is a promise. It has no legal backing. So here, if they have said so and they resiled from their promise, can you hold them responsible under any law? The answer is no. Those are the arguments I was even expecting them to go and canvass at the Supreme Court. Unfortunately, I don't think such argument was even a canvass at all. That what is the status of INEC manual guideline vis-a-vis the provisions of the Act, the Electoral Act? Like I said, in an electoral jurisprudence, we are evolving, we are growing. We have not yet got there. There are still rooms for amendments to include the issue of IRF, right from the polling units to the portal, where the entire public all over the world can view as voting is going on. Our people should stop criticizing our justices. They are doing the work and they are doing it very well, irrespective of the non-conducive atmospheres. We should commend them. We should encourage them. And for the National Assembly, they should listen to the people. They should accommodate opinions. For us to have an electoral heart that will give confidence to the public. But remember, the massive law-legal latter, law-legal faranda. The law as it is and the law as it ought to be. So the law as it is today is the law. How it ought to be is an academic issue. So, but the academic issue can be brought into reality if it's incorporated in the law. That's my take on this matter.
Now, away from the Supreme Court, we turn our attention to the second annual conference of the National Association of Family Court Judges, Magistrates, and other family court practitioners, which held in Port Harcourt, the Rivers State capital. Here are some of the highlights from that event. Judges and magistrates of the family courts across the country converged at the Justice Mary Odili Judicial Institute in Port Harcourt, Rivers State, alongside other family court practitioners, partners, and their representatives for the second annual Family Court Conference, which held from October 24th to the 26th. The Rivers State Judiciary is hosting the conference in partnership with the Green Horizon Institute. The Chief Judge of Rivers State, Justice Simeon Amadi, and the Acting Chairperson of the National Association of Family Court Judges and Magistrates, Justice Eberechi Yesamwike, leads other members of the State Judiciary to welcome the conferees to this event, which kicked off with a welcome cocktail in the evening of Monday, October 23rd. Participants were treated to a fine evening of music, good food and drinks, and it provided an opportunity for meeting, greeting, and networking.
A cocktail party is not where we make long speeches. It's an occasion to interact. We are supposed to be knowing each other. Today is for us to familiarize ourselves, whether you are chief judge or you are president. Here, no level. All of us are equal. We have to go around, shake hands, introduce ourselves to each other. I declare the cocktail open.
I want to welcome you again to Port Harcourt, as my Lord did, and to tell you that this is going to be a very, very interesting conference. We're going to have a lot of learning as well as a lot of fun. And I'm sure this association, which I will say had gone into a state of comatose, is just about to be reawakened, to be revived, and re-energized. And we're going to do wonderful things in the best interest of the Nigerian child. I want to use this opportunity to specially thank my Lord, my boss, my CJ, Honorable Justice Simeon Chibuzo Amadi. We'll have an excursion around River State to see the sights and sounds of River State. We will also have a barbecue night, and of course, together with our conference and all our sessions, I'm sure we're going to have a great time. To stay behind, have more drinks, there's more food, there's music. If you want to dance, please feel free, do as you like, but come quickly for tomorrow's lectures. Thank you. God bless you all.
very next day, the judges, magistrates, lawyers and the other participants were back at the same venue for the opening ceremony. Invited participants here include lawyers practicing in the family court counselors and registrars, law enforcement agencies concerned with children and family matters, Sharia court judges and caddies handling cases involving children, and even persons interested in building expertise in the area of child justice. The conference has the theme, Repositioning Child Justice Administration in Nigeria.
Having come into existence, the primary mission of the National Association of Family Court Judges, Magistrates and other family court practitioners of Nigeria is to advance the effective implementation of the Child's Rights Act 2003 and all other related legislations through advocacy, capacity building, knowledge sharing, and effective judicial actions. Over 17 million children are reportedly out of school, while millions more are abandoned, abused, and neglected on the streets and in foster homes, culminating in a daily increase in juvenile delinquencies. We cannot continue to allow such negative social ills to impact our families, women, and children, and expect a bright and prosperous future for our nation, states, and communities. As judges, magistrates, and practitioners of the family court, our ability to effectively deal with family and child law cases is also critical to mitigating the social crisis and contributing to the progress of our country, states, and communities. I am confident that with the array of gifted speakers, panelists, and discussants, this conference will feature amazing presentations on current and cutting-edge topics that will inspire us, broaden our knowledge, and provoke discussions about the issues affecting the advancement of the family and child court systems in Nigeria.
Retired Justice of the Supreme Court, Justice Mary Odili, emphasizes that children must be protected, while the host Chief Judge speaks on the need to strengthen the justice system.
The Child Rights Pledge, which underscores that the child must be honored and protected, our duty to guide, counsel, and love every child, and in so doing shield them from public harm and private abuse.
The theme of this conference, Repositioning Child Justice Administration in Nigeria, is very germane, considering the alarming upsurge in crime and other unwholesome acts perpetrated against children in our society, and the need to strengthen the child justice system to ensure a more robust and efficient justice delivery in the sector.
There were also presentations from the Chief Judge of Sokoto State and the Rivers State Commissioner of Police.
There are so many abuses on the rights of child and family in general. We have so many abuses ranging from rape, indecent assault, unnatural offenses perpetrated against children and young persons. I believe that with the establishment of family court in all jurisdictions, it will help to minimize the scourge going on right now.
Recently, the Rivers State Police Command has received several reports, cases of defilement, rape, incest, and other domestic violence-related crimes, and cases are charged to court. But the processes sometimes are delayed because there are no special and dedicated court to treat such cases.
Then followed training sessions from expert facilitators on child justice administration and robust discussions of the issues of the complexities that arise within the family, especially as it relates to children and the rights of the child. While answering questions on the abuse of children, former First Lady of Rivers State and Judge of the State High Court, Justice Eberechi Nyesom Wike, seeks harsher punishment for those guilty of defiling minors.
I want to believe that the act of defiling a child is a barbaric act. That comment I made about amputation sounds barbaric, but I do believe that barbaric acts should meet barbaric consequences. It might not be the best way to go, I want to think that life imprisonment is a lot of punishment, maybe enough to, fit that crime. But the thing is, when you look at the sufferings of these minors that are being abused in this way, and the fact that nothing really happens to them by way of putting them in a better position. If you imprison somebody for committing a crime, what does it do to the victim? What does it do for the victim is what I'm asking. Nothing. Some of them have infections from the process. Some of them die from the pain and the trauma. Some of them die even from the infections. So what happens to those children? I think we're sitting down and watching our next generation just rot away.
She also wants the lawmakers to do more about these issues.
Why will the law, the Criminal Procedure Act, insist that there should be corroboration? In other words, when the child comes and says, this is what happened to me, then you expect the child to bring somebody, or somebody should have noticed that something like that happened. And these things are not done on the streets, are they? They don't come out in front of the house and do them. They do them behind locked doors. So who is going to corroborate? I am of the opinion that when laws have stayed for 20 years and more, or even less, they should be reviewed. Because things change. Law is not static. That part of corroboration is an evil in that law. It makes it difficult and almost impossible to prove a case against the defendant. And where does that leave that child that has been abused? We don't want our Nigerian children in that position. We owe them that. We should do better by them.
On the last day of the conference, the conferees held elections to vote in new leaders for the association, and the acting chairperson, Justice Eberechi Yesom-Wike, was elected unopposed as president in recognition of her hard work, sterling leadership, and commitment to the repositioning of child justice administration in the country. Conferees, who were also treated to the sights and sounds and hospitality of the host state, speak about some of the lessons from the conference.
We have learned so much. We are going back to our state to see where we can improve upon, and then do things that we have seen here in our state.
Those of their colleagues in different states, they have missed the fun part of all of this, the different activities we had that took us out, and they have just missed, all the camaraderie and the joy that has been here amongst all of us.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtrooms.
We begin with a report that the Court of Appeal Abuja has upheld the election of Mr. Joshua, the son of Professor Jerry Ghana of the People's Democratic Party, for the Lavin Mokwa Edati Federal Constituency in Niger State in the House of Representatives. The Appellate Court set aside an earlier judgment of the National and State Houses of Assembly Election Petitions Tribunal, delivered September 11, which nullified Mr. Ghana's election. In a unanimous decision, a three-member panel of the Court of Appeal upheld the argument by lawyer to Ghana, Akinlolu Kehinde, that the tribunal was wrong to have held in favor of the petitions of Abdullahi Usman Gbatamagi and the All Progressives Congress. The court held that the appeal filed by Mr. Ghana, who is the Deputy Chairman, House Committee on Power at the Federal House of Representatives, was meritorious and proceeded to allow it. Still from the Court of Appeal Abuja, which affirmed the election of Senator Emmanuel Udende as validly elected senator for the Benue North East Senatorial District. Consequently, a three-member panel of the Appellate Court, led by Justice Abimbola Adejumo, set aside the judgment of the State National Assembly Election Tribunal that nullified his election in favor of former Senator Gabriel Soswam of the People's Democratic Party. The court unanimously said it was satisfied that Mr. Soswam was not the valid winner of the senatorial election that held in Benue North East on February 25. The Appellate Court faulted the judgment of the tribunal, which returned Mr. Soswam of the PDP to the Senate after it nullified the election victory of Mr. Emmanuel Udende of the APC. The Court of Appeal Abuja Division has upheld the judgment of the Kogi State Senatorial Tribunal, which September 6 stacked the candidate of the APC, Mr. Abubakar Sadiq Ohire, as winner of the Kogi State Central Senatorial election. A three-man panel of the appellate affirmed the judgment of the tribunal shortly after it dismissed Mr. Sadiq Ohire's appeal for lacking in merit. According to the court, he failed to provide convincing evidence why the judgment of the tribunal should be set aside. The appellate court subsequently held that Natasha Akpoti-Uduaghan of the People's Democratic Party won the majority of lawful votes cast at the poll and is declared winner of the Kogi State Central Senatorial District poll. Finally, from the Court of Appeal Abuja, which reversed the nullification of the candidacy of the All Progressives Congress APC, Chief Timipre Silva, Justice Binta Zubeiru, who delivered the lead judgment, held that the Justice Donatus Okorowo of the Federal High Court was wrong in ordering the sack of Mr. Silva as a candidate of the APC in the November 11 governorship election in Bayelsa State. The appellate said that the issue of jurisdiction is fundamental in an election matter, and since the lower court had no jurisdiction in the first place, all actions taken in the matter is declared a nullity. Justice Zubeiru also awarded a cost of 1 million naira in favor of Mr. Silva.
And that's the program for today. If you missed any part of it, you can find it on past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shayeli. Thank you for watching.